Good evening, everybody. I hope you're all doing well. My name is Sana Parvez and I am the legal expert for Hitbullseye. In today's video, we shall be discussing regarding judicial appointments and the two methods of doing judicial appointments, that is, the Collegium system versus the NJAC conundrum. So, why are we talking about this in the first place? Is that recently Kiran Rijiju, who is the Union Minister of Law and Justice, made a certain remark on the opaqueness of the current judicial system appointment. That is, following this thing, the Vice President of the country, who is Mr. Jagdeep Dhankar, stated in the Rajya Sabha that it is high time that the Collegium or the Supreme Court needs to have a relook at the way in which appointments are done in the higher judiciary. That is to say that Mr. Vice President stated that essentially what happens is that parliamentary opinion or parliamentary power of making the NJAC, of making a particular way of judicial appointment through constitutional amendment has been absolutely disregarded by the Supreme Court, and it is eventually what should be upheld. So in this regard, Mr. Vice President stated that it is never too late to have a relook at the same, and that is why today we are going to discuss about the two methods of the judicial appointment and why is the method that we follow correct or incorrect. So, with this view, we shall first of all discuss what is a collegium system in the first place. Second, genesis of the collegium system. Third, the criticism of the judicial system. And next, the NJAC, the 99th Amendment of the Constitution. And lastly, we will discuss why is it now that we are discussing all of this. So, first of all, in order to understand the judicial appointments of the higher judiciary, when we are talking about the higher judiciary, we are talking about the appointments of the judges in the Supreme Court and the High Court, as well as the transfer of judges of the High Court. So, that is how we talk about the appointment of judges in the higher judiciary through the means of two articles, Article 124 and Article 217 of the Constitution. Now, first of all, let us have a look at the articles. Firstly, establishment and constitution of the Supreme Court. Article 124 establishes the Supreme Court and clearly states that there shall be a Supreme Court of India constituting of Chief Justice of India, and until the Parliament by law prescribes a larger number, if not more than seven other judges. Now, this is 33 other judges, and currently the strength is 33 plus 1, that is 34 judges. But this is the provision that we are seeing as it stood before the amendments. Every judge of the Supreme Court shall be appointed by the President by the warrant under his hand and a seal after consultation with such of the judges of the Supreme Court and of the High Courts. Now, what we have to understand essentially is this phrase, after consultation with the judges, with such judges of the Supreme Court. This after consultation with essentially such judges, that is the CJI, plus a few other judges of the Supreme Court, makes how many ever n number of judges, makes the collegium. So what we have understood in this case essentially is that collegium word has per se not been used in the articles, and it is an interpretation of the Supreme Court. Similarly, if we see in the cases of the judicial appointments in the High Courts as well, if we read Article 217, it states the same. Every judge of a High Court shall be appointed by the President by a warrant under his hand and seal after consultation with the Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than the Chief Justice of India, the Chief Justice of that High Court. So essentially in this case as well, it is not been a categorical mention of the collegium system per se, but now let us have a look at what is the collegium system essentially, and how did it come into being if it wasn't present in the constitution in the beginning. So in order to understand this, let us have a look at what the collegium system is. The collegium, if we discuss about the English word collegium, it is essentially a group of people and nothing else. It is simply a group of people in which each person has one vote, and every person's vote is equal to the other person. In the context of the Collegium of the Supreme Court, it comprises of the Chief Justice of India as well as four senior most judges of the Supreme Court. The concept is not rooted in the constitution, but it has been developed by the judgment. So as you saw in the previous slides, in article 124 and 217, it has not been given per se that the collegium system shall appoint the judges. However, we shall see subsequently how this came into being. In this, certain names of the judges, of the prospective judges rather, of the Supreme Court and High Court are given by the Collegium, and the names are given to the President. So the names are given to the central government to go to the President, and before the names go for assent or go for final appointment to the president, they go through the central government. The central government does not have a major role to play in this regard, and it has only three duties to fulfill. The three duties are: it has to firstly conduct an inquiry by the intelligence bureau as to any doubts, any qualms about the judges, and about basically the credibility of the judges. Secondly, it can raise any objections onto the credibility of the judges, and it can seek clarifications from either the judges or the collegium itself if they think that the person who is prospectively being appointed is not suitable for such appointment. However, if the government does raise any objections or on the credibility of that person, and if the government is not satisfied, and if the government does make any recommendations of any other name, or does tell the collegium not to appoint a certain person, in that case also the hands of the governments are essentially tied, and whatever the collegium decides uh, is going to be the last final word on this. So essentially the government can overrule what is being said by the government, government, yes. So next, let us discuss the genesis of the collegium system, essentially how the collegium system came into being as it stands now. Earlier, from the time of the independence to the second judge's case, that is 1992. Earlier, there was a lot of involvement of the executive because of the articles that we read earlier. The president had to give an assent, but the president's assent was considered an assent of the president after the advice of the prime minister with his council of ministers. That is the assent of the whole of the executive. That is why the involvement of executive was almost just as much as the involvement of the judiciary as well. Therefore, a petition was filed which contended that CJI should be given veto power. Contended that CJI should be given veto power, and if the CJI is of the opinion that a certain judge should not be appointed in this regard, then he should not be appointed by the executive. The interpretation of the word consultation was done, and the court held that it meant to say the last word essentially lays with the executive, and the primacy would be given to the executive and not the judiciary as far as the appointments were concerned. So essentially, if you have to see, the first judge's case sided with the government and not the Supreme Court in this regard. However, in 1992, there came a second judge's case, or what we call Skaura versus Union of India, that is Supreme Court Association, Supreme Court Advocates on Record Association versus the Union of India. It's a case of 1992, and it was a nine judges bench. It essentially overruled the first judge's case, and it gave primacy to the judiciary with regards to appointments. It basically stated that presidential recommendations are not binding in this regard, and the role of the executive is very limited. Whatever the collegium will say, that is to say that whatever the CGI plus the senior most judges of the Supreme Court will state will held to be binding, and the president will have to adhere to the recommendations given by by the collegium. Now, the same thing was again reiterated in the third judge's case, which upheld the second judge's case. The third judge's case was a reference special reference of 1998. Proceeding, now let us discuss what is the criticism of the collegium system. Firstly, the criticisms of collegium system, or the ineffectiveness of the collegium system, was highlighted in the first place when Shanti Bhushan filed a writ petition stating that the Chief Justice of India had disregarded the senior most judges in appointments, and it was essentially the whims and fancies of the CGI at that point of time in nomination of 8 to 10 judges. Secondly, again, it came into controversy when Justice Dina Karan was appointed in the Supreme Court, and it was stated that he had some allegations of corruption leveled against him, and he was still appointed without any accountability. He was appointed to the Supreme Court, and thus the credibility of the whole judicial appointment system by the collegium system was again brought up. Second, it is time and again it has been brought up that the whole process is very opaque, or it's a closed door affair, or it lacks transparency. Essentially, to say that no meetings are discussed, no recommendations, which recommendation was made in the first place, which recommendation was eventually rejected. All of it happens behind closed doors, and what we get to see is only the final names. This is not open to the right to information. All the affairs of the collegium are basically cannot be ascertained or cannot be adjudged or discussed by the means of the Right to Information Act. Thirdly, it is contrary to the constitutional intent. Many ministers have now and again stated that the initial constitutional intent was supposed to be what was given in Article 124 and 217, which is that the president, that is essentially the executive, is going to have the final say in the appointment of the judges, and it is not wholly a word of the judges, or on the basis of recommendations of the judges. Next, the criticism was equating independence with mode of appointments is fallacious. How is it fallacious? As we all understand that Article 50 of the Constitution of India talks about separation of powers of three organs of the government, that is the executive, legislature and the judiciary. Now we all know that executive and legislature have some overlapping. However, judiciary is considered to be the most independent organ of the three. However, it was said that in order to uphold the independence of the judiciary, it is not necessary that the mode of appointment should also be independent. The next point is nepotism. We have seen many times that a lot of people who are relatives of the judges, or favoritism kind of basically appointments based on favoritism keep taking place, and that is why it was criticized for being nepotistic. Next, appointments lack representative character. Many ministers have stated, or many times it has come into controversy, that only a particular caste is dominating the Supreme Court. All the judges of the Supreme Court basically belong to one particular caste, and there is no true representation because it is done on merit. But at the same time, how we see in the Lok Sabha or how we see in the Rajya Sabha, that kind of representation is not there in the Supreme Court. The last criticism was that pendency even after increase of number of seats. Now, earlier the number of seats was 9,016 seats all over the high courts. We are only talking about the high courts and not the Supreme Court in this case. The legislature further increased these seats to 1,108 seats. However, it was seen that even after the increase in these seats, 380 seats remain pending, which the Collegium has failed to appoint so far. Now, in this regard, many ministers or many politicians stated that there is a pendency, there's a long pendency of cases in the high courts, and non-appointment of judges in this points at the ineffectiveness of the collegium system, that is only 5 people have to make all the appointments. Next, we shall discuss in order to address these criticisms in 2014 NJAC Act or the National Judicial Appointment Commission was established qua the constitutional amendment of 2014. This was the 99th amendment of the constitution, and this essentially increased the role of the government in the appointment of the judiciary. How it increased the role of the government, or how it increased the role of the executive. Now it was held that article 124 and 217 were changed slightly to mean that the appointments of the higher judiciary shall be made by one, a committee of, firstly, the chief justice, secondly, two more senior judges of the Supreme Court, thirdly, the union minister of law and justice, and fourthly, two eminent persons. Now, these two eminent persons shall be selected by a committee of further the PM, the CJI, and the leader of the opposition. So that is how, essentially, if we see that there would be a balanced role, 3 people from the executive, or 3 people who shall have an influence of the executive, and 3 people from the judiciary, so as to make it a more balanced committee of appointments. However, the very next year, this appointment, as we discussed, this amendment was brought in 2014, and in the subsequent year, that is 2015, it was struck down by the Supreme Court of India, saying that it was unconstitutional, and it attacked the independence of the judiciary, and it attacked the what was envisaged under Article 50 of the Constitution of India. This was done in the case of Supreme Court Advocates on Records Association versus Union of India. Now you have to understand that this is a case of 2015, and the second judge's case is also of the same name, but it is a case of 1992. In this particular case, the Supreme Court quoted that the NJAC attacked the basic structure doctrine, and the basic structure doctrine essentially states that judiciary appointing the judiciary, that is, the collegium appointing the judiciary, is the very heart and soul and part of the basic structure of the constitution. However, this judgment was further criticized by legal experts as well, and especially certain ministers, saying that it did not adhere to any natural justice. Meaning to say that this is essentially, as we have understood by far, it is essentially a tussle between the government and the judiciary. So how can in this case the judiciary be the own judge in its case? As we see, a principle of natural justice is that nobody can be a judge in their own case. So that is why the conflict was brought up in this regard. So now these discussions are again happening, and as we discussed in the beginning of the video, Union Minister Kiran Rijiju stated that the NJAC striking down should be relooked by the Supreme Court. In this regard, the opposition leaders, the many opposition leaders, have this to say that only because the ruling party feels that it does not have a control over the Supreme Court as it might have had before. Now the Supreme Court, now the central government again wants to hold the strings back together. So let us see what the Lok Sabha member Shashi Tharoor had to say. He essentially stated that we should do everything possible to preserve the independence of the judiciary from the executive. Subordinating the judiciary to the executive control would be to compromise its independence at the very moment of its appointment. So essentially, uh, it's a statement in favor of judiciary appointing the judiciary or in favor of the collegium system. Next, the Trinamool Congress's Sukhendu Sekhare also stated something like this, stating that the way the government is bent on encroaching on the constitutional authorities, particularly the judiciary, our party may consider the present unpleasant scenario in its proper perspective. So, this is we learn from this that this is only one party that wants this bill or NJC to be upheld again. Now let us discuss what is the statement or what is the opinion of the Supreme Court over this. Now, in a petition, the Advocates Association Bengaluru versus Sri Varun Mitra, Secretary Justice, this case was filed in the year of 2021, and a three judges bench heard the case. Justices Sanjay Kishan Kaushal, Abhay Asoka, and Vikram Nath. In this, answering to the apprehensions or answering to the allegations of the vice president as well as the union minister of law and justice, this bench stated that firstly it stated that it is the center who is not approving the 11 names reiterated by the Supreme Court. So, when were discussing the criticism of the collegium system, we discussed that there is a lot of pendency which the collegium system is not addressing, and they're not appointing adequate number of uh, judges when the adequate number of vacant seats are there in various high courts. However, according to the opinion of the Supreme Court, what it had to say was that it is, as we discussed, it has to go through the process of being approved by the central government also. The central government, it was held in PLR Projects Limited versus Mahanadi Coalfields Private Limited, that this clearance should be done in not more than 3 to 4 weeks. However, it was stated by the bench that the central government takes many months in order to clear this list, and also at the same time it does not clear the list once for all. It further stated that sometimes it clears some names, and then it withholds some names, and sometimes when you do this, you pick some names from the list and not the others. What you do effectively is to disrupt the seniority. So as a consequence, not only the seats lay vacant, but also the seniority of the persons is affected. When the Supreme Court Collegium makes the recommendations, many factors are to be kept in mind, and Collegium system stating this, the bench stated Collegium system is still working on its effectiveness. It is the law of the land. It does need some improvements, yes. However, it is the law of the land and it should be upheld. This is with regards to the constant ongoing debate about the Collegium versus the NJAC. Please write your opinions in the comments. I hope you all like the video. If you did like the video, please share, like, and subscribe. Thank you.